Welcome to the Real Free News audio podcast. Today, explore debates on legal accountability, citizenship, and societal policies with a balanced look at evolving justice concepts and their potential impact on future governance. The concept of banishment as a legal penalty has deep historical roots, stretching back to ancient civilizations where expulsion from a community served as both punishment and protection for the collective. In contemporary legal systems, particularly within the United States, this practice has largely been supplanted by incarceration and rehabilitation, reflecting a shift toward reintegrating offenders into society. However, recent debates surrounding immigration policies, judicial decisions, and legislative actions have reignited interest in banishment as a potential mechanism to address perceived threats to national stability. This essay explores the reemergence of banishment, extending it to include collective punishment of entire families as a response to crimes such as open border advocacy, fraudulent practices, and judicial rulings with long-term societal consequences. Central to this discussion is the notion that certain acts, whether committed by politicians, business leaders, or judicial figures, may warrant removal not only of the individual but also of their familial networks, thereby severing their influence and deterring future transgressions. The argument posits that rehabilitation fails to address the severity of crimes deemed to undermine the collective well-being, such as those facilitating illegal immigration or establishing problematic legal precedents. This perspective challenges the prevailing rehabilitative paradigm, suggesting that permanent exile, coupled with loss of citizenship and asset confiscation, could restore domestic tranquility by eliminating persistent threats. The inclusion of family members in this punishment framework introduces a novel dimension, aiming to amplify deterrence and prevent residual subversion. This essay further examines the legal and ethical ramifications of holding public officials accountable across generations, particularly for decisions with foreseeably harmful outcomes. The focus extends beyond immediate penalties to propose a system where the lineage of decision-makers bears responsibility, reflecting a belief that the long-term impact of judicial or legislative actions should influence the behavior of those in power. By analyzing historical precedents, current legal constraints, and potential new doctrines, the study seeks to construct a theoretical framework for implementing such measures. The discussion navigates the delicate balance between justice and retribution, proposing ways to introduce these ideas into public and legal discourse without inciting immediate conflict, thereby fostering a scholarly exploration of accountability in modern governance. Historical foundations of banishment and collective punishment. Banishment has been a recognized penalty across various cultures, from the Roman practice of deportatio, which stripped individuals of citizenship and property, to the Puritan exiles of colonial America, where dissenters were removed to preserve community harmony. This form of punishment was often accompanied by social ostracism, ensuring the banished individual could not return without facing severe consequences, such as death under Roman interdictio acqui et ignis. In medieval Europe, banishment extended to families in cases of political crimes like treason, reflecting a belief that familial ties could perpetuate disloyalty. These historical examples suggest that exile was not merely punitive, but also a strategic tool to maintain societal order by removing perceived threats. The concept of collective punishment, including the banishment of entire families, finds parallels in ancient practices such as the Inca Mitma policy, where groups were relocated to assimilate conquered populations, and the English Frank Pledge system, which held communities liable for individual crimes. In Rome, the punishment of a traitor's family through damnatio memoriae erased their social standing, serving as a deterrent against future rebellion. These instances indicate that collective responsibility was employed to incentivize group monitoring and discourage subversive behavior, a principle that could be adapted to modern contexts where individual actions have widespread impact. The effectiveness of such measures, however, depended on the size and cohesion of the targeted group, with larger or wealthier families posing challenges to enforcement. Despite its historical prevalence, the application of banishment and collective punishment has waned in modern legal systems, particularly in the United States, where constitutional protections such as due process and equal protection under the 5th and 14th Amendments have limited its use. Interstate banishment has been deemed rare and constitutionally questionable, while international exile of citizens is effectively prohibited, reflecting a shift toward individual accountability. Nevertheless, the resurgence of interest in these practices suggests a need to revisit their legal viability, potentially through new legislation or judicial reinterpretation, to address contemporary issues like immigration and judicial overreach. This historical lens provides a foundation for reimagining accountability in a manner that aligns with current societal needs. Legal challenges and contemporary applications. The legal landscape of the United States presents significant obstacles to reinstating banishment and collective punishment, primarily due to constitutional safeguards that prioritize individual rights. The 5th and 14th Amendments mandate due process, making it difficult to justify the expulsion of citizens or the punishment of innocent family members for an individual's crimes. Historical cases such as Cooper versus Telfair in 1800 have restricted banishment to extreme circumstances like wartime treason, while the prohibition on corruption of blood in the Constitution's treason clause further complicates collective liability. These constraints necessitate a re-evaluation of legal mechanisms, potentially through constitutional amendments, to accommodate a system of exile as a post-incarceration penalty. Contemporary debates, particularly surrounding immigration, have fueled discussions about limiting birthright citizenship, as exemplified by the 1898 Supreme Court decision in United States versus Wong Kim Ark, which affirmed citizenship for those born on U.S. soil. Critics argue that this ruling, alongside modern policies perceived to enable illegal entry, has contributed to societal challenges, prompting calls for accountability measures that extend beyond traditional prosecution. The recent Executive Order 14160, issued in January 2025 and currently under Supreme Court review, represents a pivotal moment that could reshape interpretations of jurisdiction and citizenship, potentially opening the door to new punitive frameworks. This context underscores the need for a legal structure that addresses both immediate and generational impacts of such decisions. To implement banishment and collective punishment, a comprehensive legal procedure would be required, involving conviction under existing or newly defined codes such as conspiracy, racketeering, or color of law violations. This would be followed by incarceration, asset confiscation, citizenship revocation, and eventual exile, with family inclusion determined by evidence of complicity or future risk. The development of a specialized tribunal, such as a national security court, could oversee this process, ensuring compliance with due process while addressing the severity of crimes against collective well-being. Such a system would need to navigate international law, ethical considerations, and public opinion, balancing the desire for security with the principles of justice that define modern governance. Criminalizing policy decisions and advocacy. The proposition that certain policy decisions and advocacy efforts, particularly those related to open border practices, constitute criminal acts introduces a novel approach to legal accountability. Crimes such as conspiracy, racketeering, and aiding illegal entry have been identified as potential charges against individuals, politicians, business leaders, or charity operators who facilitate immigration perceived as an invasion. Additionally, color of law violations and abuse of power could apply to public officials who misuse their authority to enable such policies, while financial and document fraud further expand the scope of prosecutable offenses. These legal categories provide a basis for targeting actions that result in measurable societal harm, such as increased crime or economic strain. The inclusion of fraud, whether financial or documentary, highlights the complexity of modern criminal networks that profit from illegal immigration, suggesting that accountability should extend to those who benefit economically. Human trafficking and money laundering add further dimensions, indicating that the impact of policy decisions may involve organized crime, necessitating a robust legal response. This perspective challenges the traditional view that advocacy or legislative voting is protected speech, proposing instead that foreseeable consequences, such as welfare abuse or violent crimes committed by illegal entrants, justify criminal liability. The severity of these outcomes supports the argument for punishments that go beyond imprisonment to include permanent removal from society. To operationalize this approach, a legal framework would need to establish clear criteria for identifying culpable individuals, potentially through a doctrine that links policy outcomes to intent or negligence. The process would involve trials under a specialized code, followed by incarceration, asset liquidation, citizenship revocation, and banishment, with the possibility of collective punishment for families. This system aims to deter future policy decisions that undermine national stability, reflecting a belief that the collective good supersedes individual rights in cases of extreme societal threat. The development of such a framework requires careful consideration of legal precedents and constitutional limits, ensuring that it aligns with the principles of justice while addressing contemporary challenges. Legislative and judicial immunity in question. Legislative and judicial immunity, enshrined in the U.S. Constitution's speech or debate clause and judicial independence doctrines, currently shields public officials from liability for their votes and rulings. This protection, affirmed in cases like Gravel versus United States, 1972, is intended to preserve the integrity of lawmaking and adjudication, allowing officials to act without fear of retribution. However, the argument arises that this immunity enables reckless or ideologically driven decisions, such as those supporting open border policies or establishing problematic precedents like birthright citizenship, which may lead to significant societal harm over time. The challenge lies in determining when immunity should be pierced to hold officials accountable for the consequences of their actions. Exceptions to immunity exist for criminal acts outside legislative or judicial duties, as seen in United States versus Brewster, 1972, where bribery was prosecutable, suggesting a potential avenue for reform. The proposal to introduce a vote as guilt or legislative accountability for harmful effects doctrine would require redefining the scope of immunity, potentially through a constitutional amendment or new legislation that sets a threshold for harm, such as crime rates or economic loss, beyond which officials could be liable. This approach would necessitate a mechanism to assess intent or foreseeability, shifting the burden from individual prosecution to systemic review, and could extend to judicial rulings with long-term impacts. The development of such a system would need to balance accountability with the need for independent governance. The critique that immunity attracts individuals with criminal intent rather than community-minded leaders underscores the need for reform to deter abuse of power. Historical examples, such as the impeachment of judges in 17th century England or the post-Civil War treason charges against legislators, indicate that accountability has been feasible in extreme cases, though modern protections have largely eliminated these practices. Proposals to limit immunity through recall elections, independent oversight, or a harm threshold clause could address this concern, ensuring that officials are held to a higher standard. This discussion opens the door to rethinking the role of immunity in fostering a legal system that prioritizes the collective good over individual privilege. Intergenerational liability and family punishment. The extension of accountability to the families and lineage of public officials introduces a radical departure from current legal norms, aiming to deter decisions with foreseeably harmful generational consequences. This concept draws on historical practices like Roman damnatio memoriae and English attainder, where the families of traitors or disgraced figures faced social or legal repercussions, serving as a warning to others. In the context of modern jurisprudence, this could mean that Supreme Court justices who establish precedents like Wong Kim Ark or legislators who vote for open border laws are held responsible not only during their tenure but also through their descendants, should those decisions lead to societal collapse, such as terrorism or crime waves, decades later. The proposal seeks to instill a sense of legacy responsibility, curbing the pursuit of moral superiority or ideological agendas. Implementing intergenerational liability would require a legal mechanism to assess the long-term impact of rulings or laws, potentially through a post-tenure review board that evaluates foreseeability and harm. If thresholds are met, such as documented increases in crime or economic instability, penalties could include asset confiscation from a family trust, citizenship revocation for descendants, and collective banishment to a foreign nation. This approach assumes that the threat to family lineage would deter justices or legislators from making ridiculous decisions, as you describe them, driven by personal grandeur rather than national interest. The challenge lies in defining the scope of liability, ensuring that only direct descendants with inherited benefits are affected, and navigating constitutional protections against collective punishment. The ethical implications of punishing innocent family members or future generations raise significant concerns, potentially violating principles of individual responsibility and human rights. Historical precedents suggest that such measures were effective deterrents in hierarchical societies, but modern democratic values emphasize rehabilitation and personal accountability, as seen in the rejection of attainder in the U.S. Constitution. To address this, the discussion could focus on voluntary legacy agreements, where officials opt into family liability as a condition of office or limit punishment to cases of proven intent or gross negligence. This framework would need to be introduced as a theoretical exploration, allowing public and legal scholars to debate its merits without immediate application, thereby fostering a constructive dialogue on accountability across generations. Conclusion: restoring accountability, pathways to a just future. The reimagining of banishment and collective punishment as tools for addressing crimes against the collective well-being represents a significant shift from the current rehabilitative focus of the U.S. legal system. This essay has traced the historical foundations of these practices, highlighting their use in ancient and medieval contexts to maintain societal order, and contrasted them with contemporary constitutional constraints that prioritize individual rights. The proposal to extend accountability to include incarceration, asset confiscation, citizenship revocation, and banishment, potentially encompassing entire families, offers a potential solution to perceived threats posed by policies like open border advocacy and judicial precedents such as birthright citizenship. The development of a legal framework to support this approach requires careful navigation of legal, ethical, and international considerations. The discussion of criminalizing policy decisions and challenging legislative and judicial immunity further complicates the landscape, suggesting that foreseeability and intent could serve as criteria for liability. The introduction of doctrines like vote as guilt or intergenerational judicial liability aims to deter reckless decision-making by linking outcomes to the personal and familial legacy of public officials. While historical precedents provide some guidance, the absence of direct modern equivalents underscores the need for new legal concepts and constitutional amendments to implement such measures. The potential for deterrence, as evidenced by public support for stricter immigration controls, suggests that this idea could resonate with segments of society seeking enhanced security. Ultimately, the exploration of these ideas must be approached with sensitivity, framing them as long-term theoretical reforms rather than immediate threats. By fostering academic and public discourse through neutral platforms, the legal community can assess the viability of banishment and collective punishment without inciting conflict. The challenge lies in balancing the desire for national stability with the principles of justice that underpin democratic governance, ensuring that any reform respects individual rights while addressing the collective good. This essay concludes that while significant hurdles remain, the discussion itself may serve as a deterrent, encouraging more thoughtful decision-making among those in positions of power. Thank you for listening to the Real Free News Podcast. Be sure to like, share, subscribe, and tell us what you think in the comment section. Visit realfreenews.com for more Real Free News. And check out the Real Free News store for real free food and gear. Tune in again. And until then, remember to keep it real. Free news. See you next time.